This is Talking to America. I'm your host, Aaron Zellman. We have a special guest today. His name's Edwin Vieira. Edwin is a practicing attorney in constitutional law, an author, and he's done quite a few articles for a website called News with Views. Edwin, welcome to Talking to America.
My pleasure, Aaron.
Today we want to talk about the Heller case, Heller versus D.C., the case that's going to the Supreme Court to theoretically determine if we Americans have a right to own firearms. As you know, JPFO has submitted our brief to the court, and what's fascinating about the show we're going to do today with you is a different point of view as to why this may not be a good idea.
Well, I think that's right. It may not be a good idea at several levels, but unfortunately that's where we are. It's gone there, and they're hearing it. In fact, this month they'll be hearing oral arguments shortly. And then I anticipate that they'll have a decision out by, the end of May, June, early June, no later than that.
Do you think that Heller was litigated on the correct constitutional theory?
Well, no, I don't. The theory that Heller used was, or is, what's generally known as the individual right theory. And it operates on the premise that you can bisect the Second Amendment. The Second Amendment reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And the individual right theory pays attention solely to that second clause, the right of the people to keep and bear arms shall not be infringed, and essentially says to judges, don't pay attention to the first one, that first clause, in relationship to the militia. Now that runs into a number of problems. The first one is that if one is interpreting the Constitution from the point of original intent, which I and many others believe is the only correct way to do it, you have to put yourself back into the legal intellectual framework of the people at that time and understand what they interpreted those phrases to mean. And the rule of interpretation in those days, how you construed a legal document, essentially said that if the document made a statement about its purpose, which the Second Amendment clearly does in that first clause, then you must interpret everything that follows in light of that purpose. So it's clear that on the basis of that rule of construction, the right of the people to keep and bear arms has to be interpreted in some way in relation to a well-regulated militia. And so that's the first difficult situation that I see that the Heller people have gotten themselves into. Members of the Supreme Court could simply ask the question, well, now tell us how this individual right relates to the maintenance of a well-regulated militia. And I think Heller's people might have a certain amount of difficulty there because, of course, they haven't predicated their arguments. They haven't developed the factual and legal record in the case on the basis of a militia-related right. Secondly, if you look at the main decision that the Supreme Court came up with in the area of the Second Amendment was in 1939, United States versus Miller. It's something of a peculiar case because it involved the National Firearms Act and the question of whether a short-barreled shotgun had to be registered under that act. When the case gets to the Supreme Court, the actual defendants, Mr. Miller and his co-defendant, didn't even file a brief. Actually, they were a couple of criminals who absconded. They had won the case in the district court. Lower court had said that the Second Amendment had to be interpreted in their favor. Gets to the Supreme Court. They didn't even file a brief. The government filed a brief that was full of what I would call modern gun control arguments. And the interesting thing is the Supreme Court paid no attention to that whatsoever. It came up with an opinion based on some historical research it had done itself, which said that in the pre-constitutional period, the period before the Constitution had been ratified, militias were in existence in every colony or independent state. These militias consisted of all the able-bodied men in the community from about 16 years old to 50 or 60 years old, depending on which colony you were in. And that the ultimate or basic principle, operational principle of the militia, was that every one of these men was required to have a functioning firearm and ammunition in his personal possession. the only thing that the Supreme Court couldn't decide in that case, which is why it really didn't give a definitive interpretation of the Second Amendment, it couldn't decide whether a short-barreled shotgun was a suitable militia firearm or not, because the record in the case, the factual presentation in the district court, was really incomplete. I mean, there was just nothing on that particular subject, and the Supreme Court didn't want to take what's called judicial notice of that question. They didn't want to decide for themselves, without any evidence put into the case, whether or not such a firearm was suitable for use in the militia. Now, I think they could have done that, because obviously in World War I, shotguns had been used in the trenches. The 1897 Winchester, I think, was reworked for use in the trenches, and it was rather notorious that they had been used. The Germans had complained and said that it was a violation of either the Hague or I think it was the Hague Convention. So it was something that certainly had been in the notoriety of international relations. But the Supreme Court didn't want to touch that. So as a result, there never was a complete determination under the Second Amendment. But what that case, United States versus Miller, clearly shows was that the Supreme Court, the first time they've looked at this in modern era, in the 20th century, last century, first time they looked at it, they realized that they had to interpret it from the point of view of that first clause, the well-regulated militia clause. They had to go back historically and determine what were the principles on which militias were structured, because that, of course, is the meaning of that terminology in the Constitution. The Constitution doesn't define it any other way, so we have to go back and look at what was the historical context in which those words were used. So just looking at that precedent of United States versus Miller, I, as a litigator, would have said, well, if I'm going to bring this Heller case, I better make my argument consistent with United States versus Miller. I might be willing to go further and say, oh, besides this militia connection, there's also some element of an individual right for people who don't have a relationship to a militia, say elderly people, for instance, who would be over 60 years old. I might make that kind of an argument in addition, but I certainly wouldn't leave out the first half of the argument, because I put myself at a decided disadvantage. So as I say, I look at this and from the point of view of the composition of the court that's there now, where at least 4 members of that court, I would think, are probably going to be hostile to any interpretation of the Second Amendment that lets people, individuals in the District of Columbia, possess guns in their homes. That the litigational strategy that the Heller people are using leaves a little bit to be desired.
Is it possible that, in theory, I guess, that both approaches arrive at the same results?
And there's your problem. It's not necessarily true that they do. It depends upon how you analyze it. The militia approach results in an absolute right, because the militia structures in the pre-constitutional era were requirements. They were actually duties to possess arms. And they were duties for people to obtain those arms in the free market by them themselves, unless they were too poor to do so, and then the government would provide them with a firearm. So that militia concept, when it became a constitutional concept, because, of course, in the period before the Constitution was written, we were all talking about colonial statutes. But when it became a constitutional concept, that right to possess a firearm really becomes a composite right and duty, and it's impossible for the government in those circumstances to have any power to regulate that right, at least in the sense of telling someone that he can't have a firearm in his possession, which is essentially what the D.C. law says. It says you can't have an operative one. It has to be broken down over the gun lock or so forth and so on, so it can't be used immediately for self-protection. Whereas the individual right theory is open to, how shall I put this, 2 kinds of limiting interpretations that the Supreme Court has come up with, all on its own, because they really don't have a basis in the Constitution. One is called the reasonable regulation interpretation, which says, yes, we have these rights in the Bill of Rights, we have freedom of speech, we have the right to keep and bear arms, and you go down that list, but all of those rights are subject to, quote, reasonable regulation in the public interest. Well, what does that mean? It means whatever the Supreme Court is willing to tolerate.